What kinds of possible help can you provide to DUI defendants? In a particular case, might you be able to reduce their time in jail or their fines, not have them have to go to DUI classes or have ignition interlock? What kinds of things can your firm do? Can your firm do? Not will they do necessarily, but can they do in a case?
Well, we attempt to try to keep our clients' ability to drive. To us, that's really the primary focus of what we do for our clients. The laws are consistently changing, the burdens keep changing, and it's really upon us to try to fight for this. But we do things like trying to get the charges reduced, trying to get the whole thing dismissed is really the goal. I provide, the service I provide includes from initially when they get the ticket all the way up to a trial. So, for instance, we have a law that says you only have 10 days from the date you got the ticket to petition to try to keep your driver's license, or it will automatically be taken for a minimum of 90 days. We step in right away and we do the petition of that. So, we do that. We attempt to try to get the matter dismissed in motion. We'll aggressively look at the facts of your case and try to do everything possible to ensure you're not convicted. That again, because of the way the law is written and the circumstances of most people's daily life, the majority of our clients are probably going to be found guilty of something. What's our goal if they're charged with a major or an aggravated offense? To try to get that mitigated down to a reduction. We work with therapists and treatment providers to ensure that the people that are going to be evaluating our clients to determine what type of alcohol treatment programs may be required. That they individuals and get a cost-effective need. In Nebraska, there's no standard for you were convicted of a normal DUI, now you have to do 8 hours or 12 hours or 15. It's up to the individual treatment provider who evaluates people to make the determination of what is normally required. For the most part, our clients end up probably with a normal alcohol awareness class. The vast majority of the clients, the majority of our clients. There's some degree of separation from when they picked up the first one way back until they get the new one. Again, we work with providers that will assist them and try to have the best outcome for them as well. Ignition interlocks, it's a viable tool for a lot of people, but the law changed about 2 years ago. It used to be you could drive anywhere, anytime, be placed within the ignition interlock. Now you can only go to and from work, to and from school, to and from treatment. It used to be you could drive to probation. You can't even drive to probation. You think ensuring that the person's not drinking and driving, and you can't do that. So we work with people to get, we work with them to let them get information to get a work permit, a notary, so I can notarize another form. We try to provide everything in terms of a full package for people who receive DUI in the state of Nebraska.
Okay, so that sounds like a big component. It's this support, in all aspects of their life. Okay.
Yeah, and I have a lot of clients that after the fact call me and say, Kelly, I have a question about this and that, and I'm always available. I'm there for people in court. Unlike some attorneys or bigger firms where you may talk to one person and somebody else shows up in court. It's me. I have an assistant who does a lot of our paperwork and stuff, and I'm their primary contact person throughout the process.
Okay, very good, very good. Next question is, what % success have you had in getting help, getting charges reduced or, getting jail time reduced in your cases? Just a general estimate.
Oh, I would say over 50% of my clients come in facing a problem DUI end up with the matter reduced down from what they thought they were facing to begin with. So, you know, it's over 50%. It's more difficult in that window between 0.1 and 0.15 in terms of what I can actually do, because there's a certain margin of error built into the machine, and it's difficult to overcome that. Even with that, there's a bad case that basically bring in an expert who says that the test result was actually below because if you factor in these givens, margin of error in the machine, he really wasn't intoxicated, and our judges said, that's nice, but we don't have to believe them. Therefore, it's up to the prior fact. In most cases, it is the judge, and you spend a lot of money and you get limited results for that. So I say 50% because I'm very successful in getting things reduced down in problem areas. Plus, I think I benefit all my clients because my goal is to get them and keep them behind the wheel of their car. And do that by proactively petitioning to have them keep their license. I do that by being here to advise them on where we can go or what we can do to keep them driving.
Okay, very good.
And I also tell people, this is worst case, and I have to advise you of that. Because it's not my job to sit here and lie to you so that when we stand up at court, all of a sudden you're looking like, you didn't tell me that, Mr. Kelly. So,
right.
I say how I've really done a lot for them because I informed them of the worst case, what could happen, and yet I was able to overcome it and get it reduced now.
Okay, very good. Very good.
And that's why I've been doing it for 20 years, and that's what I think.
Yeah. Well, again, it sounds like you definitely have your clients' concerns in hand. I can hear it by what you're saying. So making sure we're recording again. All right. All right. Next question. Is it wise to take a DUI case to trial or to settle beforehand? Given a non-aggravated set of circumstances.
That's a very good question because a lot of times, if you settle a case, you may end up with the same result that you would have if you took the matter to trial. So, what I tell people is this is what's going to happen if we accept the agreement, if we get it all locked out. In most cases, the judge is going to do what the agreement says. So they have an absolute right to change whatever because they're the judge. So they have a right to sentence the person according to the law. We always weigh that based on what could be the ramifications if we don't resolve the case and set it to trial. So, in probably 95% of the cases, a person who's here for a first offense is going to receive probation if their attorney or, if I do what I'm supposed to do and if I can mitigate the offense. If we take the matter to trial, the judge may, and it's happened in a number of cases, aggravate them or punish them for trying. But if the facts are such that we do have good arguments, I've never had a judge say, well, you took it to trial and I really didn't believe it, so I'm going to have to fine. So, for a benefit to set a matter for trial, there certainly is because it puts the other side to provide what we're looking for in terms of this position. Is it wise to take a matter to trial where there are no issues? I really don't believe there is, because I can get the other side to agree to certain things, and we might as well take what we take what we know than what could come out. A good example is in Lancaster County, or Lake, state capital.
Right.
The county attorney ran on a platform that he does not plea bargain DUI. And they don't. I mean, they will take a bad case for them to trial based on it. But what I've found is the judges understand that. They don't punish people for fighting their cases. They will treat each individual based on the circumstances of the case. Now, that doesn't mean they won't follow the law. They certainly do.
Right.
Judges are more inclined to provide people with reasonable sentences based on that policy. So a lot of times, if the facts are such that we're not going to be able to overcome this, what I do is I step in and say, okay, let's get this all done in advance so that when we come into court, we can resolve the case by I mean, they'll dismiss other charges, but they won't dismiss the underlying DUI. But then we can step forward and have the judge, maybe if they're facing jail, they get house arrest because we get everything in place. So, or they need to work, or we can keep their job and we can give them a deadline for when they have to complete things. Plus, the court's more inclined maybe to waive some of the required fees as opposed to punishing them more by adding fees on top of it. So, there are certain benefits to taking matters to trial because it punishes a prosecutor who's not willing to provide offers. But there's no benefit if it does not benefit the client. And they're the ones that make that decision, I think, full advice to counsel.